A federal judge just tore a hole in the National Firearms Act, and he did it without mentioning the Second Amendment.
The fight over the future of suppressors and short-barreled rifles just reached a historic and monumental outcome.
The structure of federal regulatory authority just endured a catastrophic structural rupture within a Texas courtroom, unleashing a legal tempest that could obliterate decades of weapons oversight in mere hours. Envision stepping into a federal courthouse, hearing that an entire enforcement mechanism accumulated over many generations stands upon a constitutional fantasy, and observing a judge issue a 66-page systematic and thorough destruction of that regime. In a broad and unprecedented ruling, United States District Judge Reed O'Connor, overseeing combined high-stakes lawsuits involving major industry players such as the silencer shop and individual complainants represented in the Jensen matter, has formally targeted the very heart of the National Firearms Act. This landmark decision has granted a permanent injunction blocking the federal government from enforcing critical registration, fingerprinting, and punishment sections of the NFA for articles bearing a zero tax stamp.
Federal court handling two consolidated cases dealing with the NFA and also the $0 tax has now essentially issued a permanent injunction against the enforcement of those NFA restrictions against the $0 taxed items.
The complete defense presented by the Department of Justice depended entirely upon the premise that federal power is boundlessly expandable and unlimited. Yet the court just etched an immovable boundary in the sand, determining that absent a working tax, the regulatory framework instantly disintegrates. To fully grasp the complete scale of what just transpired, one must carefully examine the legislative transformation that planted this constitutional time bomb. After the enactment of comprehensive federal law that completely eliminated manufacturing and transfer taxes for suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons, slashing the price from $200 directly down to nothing, a deep legal contradiction emerged.
When they removed the tax stamp from $200 to $0, that effectively made the part of the NFA that requires you to register suppressors, SBRs, and SBSs irrelevant. It made it completely useless because the whole point of the NFA was to collect tax.
Historically, the United States Supreme Court affirmed the constitutionality of the National Firearms Act solely as an implementation of Congress's Article 1 taxation authority. The underlying reasoning was straightforward and absolutely unassailable. If you impose a tax on an object, you may regulate it, but what becomes of the regulatory machinery when the tax authority completely ceases generating revenue? The primary battlefield in the Northern District of Texas, where attorneys contended that a tax yielding $0 stops functioning as a tax altogether, stripping Washington of its fundamental constitutional authority to require compliance, background investigations, and federal enrollment. Judge O'Connor's carefully constructed and detailed opinion sliced directly through the administration's legal gymnastics with exacting accuracy. The court stressed that an indispensable, unavoidable characteristic of any legitimate tax under Article 1 is the genuine and actual production of revenue. God fundamentally.
Essentially, he found that if there is no revenue, that means there is no taxing powers. The court here emphasized that an essential feature of any constitutional tax is actually raising revenue. Once Congress zeroed out the making and transfer taxes, the NFA's registration scheme lost its sole constitutional anchor.
When Congress reduced the tax rate on suppressors and short-barreled rifles down to nothing, it unintentionally extracted the critical keystone from the entire regulatory arch. The federal administration attempted a frantic and desperate redirection, claiming that the special occupational tax on weapons merchants might somehow retroactively rescue the individual enrollment demands for ordinary Americans. The court flatly refused that rescue line, deciding that compelling extensive criminalized enrollment obligations upon private individuals merely to sustain a commercial tax grossly overreaches Congress's designated authorities. One simply cannot extend a taxation power to command federal enrollment for non-tax objects possessed by private persons. The judge likewise explicitly dismissed the administration's claim that cataloging individual firearms reinforces the special occupational tax on weapons and their merchants. The court maintained that compelling extensive enrollment demands upon ordinary Americans solely to bolster a commercial tax surpasses Congress's designated authorities, and he stated clearly that Congress may not extend its taxation power to demand enrollment for non-tax objects belonging to private persons. Unwilling to halt there, the DOJ deployed its final reserve weapon, the Commerce Clause. Administration lawyers claimed that Interstate Commerce Authority could separately sustain the statute and preserve the existing NFA enforcement apparatus. But Judge O'Connor resolutely closed that avenue too, noting that Congress adopted these particular NFA sections exclusively under taxation authority and never once referenced the Commerce Clause when originally drafting the legislation. Drawing upon recent Supreme Court decisions curbing federal overextension, the court decided that the judiciary cannot merely rewrite historical record or invent an entirely fresh statutory objective to salvage a collapsing administration argument. The administration claimed that alternatively, interstate commerce authority might sustain the statute here and maintain the NFA as a valid, legal mechanism. Judge Hendricks resolutely blocked that claim, deciding that Congress adopted these particular NFA sections exclusively under taxation authority, and they never employed the Commerce Clause whatsoever. Juddy, since the complainants secured absolute and total triumph on structural Article 1 taxation foundations, the court expressly refused to address the secondary Second Amendment assertions, dismissing them without prejudice. This tactical decision leaves those Second Amendment positions fully armed, completely untouched, and prepared for deployment in subsequent appellate conflicts, if necessary. The direct practical implications of this ruling are absolutely staggering, though they arrive with an anxious, high-stakes countdown firmly attached. The rabbi I encountered this evening stands as a complainant in one of them, and within it, he contends that the county infringes upon his Second and his First Amendment protections, and further that it actively bars Jewish worshippers from defending themselves during a disturbing surge in anti-Semitism. The permanent injunction expressly forbids federal agencies, including the Bureau of Alcohol, Tobacco, Firearms, and Explosives, together with the Department of Justice, from imposing NFA enrollment requirements, Form 1 and Form 4 handling, fingerprint collection, and non-compliance felony sanctions against the complainants, their business operations, associational affiliates, and present or prospective clients. Nevertheless, in a development that amplifies the dramatic tension, Judge O'Connor suspended enforcement of the final decision for precisely 7 full days. This brief interval provides Washington a slender pathway to rush to the United States Court of Appeals for the Fifth Circuit to seek an emergency stay while the appeal proceedings continue. Legal experts and court observers unanimously predict that the DOJ will saturate the Fifth Circuit calendar instantly, striving to preserve existing conditions before the deadline expires. Should the Fifth Circuit ultimately reject the administration's emergency stay petition, the permanent injunction will detonate into immediate and complete force for the involved parties, establishing an unparalleled legal terrain. Such a result would generate enormous cascading consequences, crossing numerous state boundaries, plunging various state-level limitations and federal compliance procedures into turbulent confusion. The clash between federal administrative overreach and constitutional limits has never been more apparent, and the coming days will establish whether this district court success maintains its position or encounters a grueling and difficult uphill fight in the appellate benches. Congress in 1934 understood they could not simply approach and prohibit a suppressor directly. Therefore, they taxed it at $200, representing several months of wages for a typical laborer during that era. And to demonstrate you remitted the tax, you needed to register the item with the authorities. In earlier times, local communities maintained an armory, and if you required firearms, everyone proceeded to the armory and retrieved their weapons from the armory. This we have drifted enormously in the opposite direction, far away from reason. And we currently possess an irrational chief executive. We possess an irrational legislature. We are simply not going to capitulate or yield. If we reach a legal position and we fall in court, then we fall in court. But I shall not surrender protections for innocent individuals merely because we confront people who are irrational. As this intense legal spectacle continues to unfold, the fundamental boundaries of federal authority are being reconstructed in real time, clearly demonstrating that the framework of American weapons laws rests upon progressively unstable foundations. That concludes our coverage for today, folks. See you in the next video.